Good morning, councillors. Good morning to members of the public and officers present as well. I think we have one gentleman over there, so looking very lonely, but you're very welcome this morning to our planning committee meeting. First of all, can I thank you for your attendance and your commitment to the cause and looking at these applications this morning. I will have to do my statutory duty to remind all attendees to use the microphones when speaking. Please remember to turn on the microphone when speaking, ensuring that you speak into the microphone itself or in the direction of the microphone. And once you have finished speaking, please turn it off. Correct usage of the system will allow for an enjoyable sound experience for all. I'd love to know. I'd love to know who wrote this. You will find, just in case if you're getting overexcited with this message, you will also find apparently a laminated copy of the detailed instructions on each row. So if you want to have a look at that, it's there. And thank you for, in anticipation of your cooperation.
Is your microphone on, Richard?
Yes. Declarations of interest. Are there any declarations of interest, please? No, thank you. Could we have confirmation of the minutes? And that was for the 8th of November. It doesn't seem that long ago, does it? Was a correct record. All those in favour, please indicate. Thank you. Unanimous. Yeah. Did everybody vote there? Yeah. That's right. Thank you. Substitute members. Have we got any information regarding substitute members? No substitute members. But we do have apologies from Councillor Dixon, I believe.
Yes.
Who sent his apologies in. So could we move swiftly to page 3, where we have the itinerary, which is obviously item 1 and then item 2. And then on to page 4, which is item 1, which is full planning application for erection of 14 residential units and associated works. And Rob Buffon is the officer this morning. So thank you, Rob.
Thank you, Chair.
We don't have any speakers. So basically the presentation will be made by the officer, and then we will pause for a moment and then go into a debate, questions, etc. Thank you.
Good morning, everyone. So the application site is Prince's Meadows, which is an existing housing development to the west of Kirkham. The application site is per the red lined image below or above. That red line forms a spare land parcel that was created subject to revisions to the original housing consent that was granted back in 2015. So just for a bit of context, the aerial image on the left hand side and the red cross depicts where the application site is. You can see we've got the A585, which is a link between the A583 that's between Blackpool and Kirkham, and then the A585, which stretches in a northerly direction towards the M55 corridor. We've got Ribby Hall, and then obviously we've got the conurbation of Kirkham and Wetham to the north. The site is a housing allocation in the local plan. It is a strategic housing allocation for 588 dwellings. As you can see from the aerial image, the first phase of the development, which is located adjacent to Blackpool Road, has been built out. And you can also see that the initial phases of the original 2015 consent have also been started, with a number of dwellings also occupied on that development. Because the site's under construction, I couldn't actually get on to the application site itself. It's used as a compound area at the moment, with the site being cleared associated with the construction of the existing development that's ongoing. But what we can see from that photograph, obviously, is the nature of houses that were originally approved as part of the 2015 consent. They are 2-storey. They are constructed of buff brick and red brick, grey roof tile. They have a front-facing aspect towards the internal access road and to the open space, which we can see there. That's the application site. I think it's here in this area. But like I say, as you can see, the site is presently underway under construction. That's the layout of the development proposed. Just to give you a bit of background to the scheme, the density will equate to 45 dwellings per hectare. As you can see as well, we've got front-facing aspects to the internal street, front-facing aspects to existing housing that will be constructed. We have strong build lines within the development, and we also have a symmetry of house types around this junction arrangement. You can see the dwellings there, how they make the corner. The scale is going to be 2-storey. We've got 64% of 1, 2 and 3 bedroom properties. The house types proposed, they are consistent with the house types within the original scheme that was approved in 2015. Materials are exactly the same. We have tree-lined streets to tie in with the tree-lined streets in the wider development, and the boundary to properties is formed by hedgerows. So, main issues, principal development. It's within Selma Kirkham. It's a housing allocation. Principal development is therefore acceptable. In addition to that, the wider allocation should be delivering 588 houses. The present planning consents across the housing allocation only deliver 528, which means we've obviously got a shortfall of about 60 houses, which we need to find. So obviously approval of this consent will act to reduce that shortfall. 14 units is not a huge amount, but nonetheless, it certainly will act to reduce that shortfall. Character and appearance wise, say the development will be seamless with the housing that's already been approved. House types are the same, so there's no issues in terms of character or appearance. There aren't any other technical issues to prohibit the development, so it is recommended for approval, subject to 106, for 30% affordable housing, health and education contributions, and I'll also refer to the late observations whereby there's been a slight tweak to the drainage detail condition. Thank you, Chair.
Thank you very much, Rob. Open it up for any questions regarding this particular development. You've heard the officer mention that it's a strategic allocation and it's within the settlement boundary, and he's made the point as well regarding the style of the houses as being consistent with the rest of the estate.
Councillor Evans.
Yes. Councillor Evans, would you like to come in, please?
Yeah, good morning, Chair. The only question really I've got is, because it's a parcel of land within an already approved development, was at the time in 2015, was this parcel of land earmarked for something other than houses? It's now had a change of use.
No, it was always intended for this land parcel to be developed for housing. What's happened though is when the 2015 scheme was revised, then there's been a slight rejigging of layout to provide additional space that's created this land parcel.
Yeah. Councillor Griffiths.
Can I ask, have we got affordable homes on this site?
Yeah.
Yeah,
There's 5 within the application site
Yeah.
for the 14 units, but that forms part of a wider affordable housing strategy for the whole site as well.
right. So are they there now?
The affordable homes?
Yeah.
Not yet, no.
Right. Thank you.
And I think I just add, I think I've read in the report that the 5 homes represents 36%, and of course we have a statutory 30%, you know, of development, but this is actually above that, so that's a good thing. Councillor Pittman.
Thank you, Chair. It mentions that in the report that the driveways are something of a problem in that they weren't quite as wide as they should be. And that this, the present 14 was reduced from 16. So I'm not quite sure whether this is a very tight fit and basically they are economising on space. It does appear that that one down on the sort of left-hand corner is quite close to the, not that, the one on right on the corner. No, that on the other side, that one. It does look as though that one's tight on the road. Are these really of no concern that basically the highways are being a little bit too fussy, or not?
Yeah, I would say, I mean, first of all, obviously we have the 2015 consent, which the applicant can build out. The driveway widths and lengths are no different than the 2015 and 2015 consent and what they are being proposed here. The applicant has sought to try and appease the highway concerns for driveway lengths particularly, but basically what the highway objection relates to is that they want to be able to, a car to pull onto the driveway, but also then for the garage door to be open, so there's that distance. Now, practically speaking, most people, if they're going to be using the garage, irrespective of whether there's that sufficient room, they'll just pull out onto the driveway, open the garage and then drive in. Practically speaking, not everybody uses the garage these days anyway. So we do have that precedent from the 2015 consent, but what I would say as well is that it's only an observation really, the highway, that they don't feel it's sufficient to recommend refusal of the plan application on those grounds.
Right. The other thing, obviously, I did go round to this particular estate to have a look. My problem with tarmac, yeah, every driveway is tarmac, which I do consider to be a little bit excessive these days. I would prefer that there's something that's more permeable than that, and I think if there's no sort of particular problem, why don't they use something more permeable? And the other thing, when I was reading about the ecology, yeah, the bats and the birds do get a mention. I'd read somewhere that hedgehogs were going to get a mention as well, but obviously this hasn't come through yet. Is there any reason why the developer can't make some sort of recommendation, or shall we say, ask the subcontractor to do a little bit more with the fencing in terms of allowing the little animals to roam free around there? I know it's a bit late because obviously the other houses haven't got anything there, but why can't they do something now? It is something that I won't say I'm passionate about, but I am mindful of.
Yeah, sure. I think like you picked up, obviously there is a much wider housing scheme that this development will form part of. That is subject to ecological mitigation, which is in the form of bat and bird boxes, and that has been replicated within this scheme. I can't recollect and tell you with assurance whether the original ecological mitigation required provision for hedgehog routes through the development or not. But I think if it didn't, and to apply it just to this scheme would kind of defeat the object really, if the wider development doesn't really make provision for those kind of routes either.
We could always make a start. I just feel it's obviously going to be a hedgehog-free zone, which is a big area, and maybe we should start to consider what the things that are moving around on the ground rather than the ones that are flying through the air.
Yeah.
I take your point. It obviously the rest of it is not, it has nothing at all.
I would say it's probably something to bear in mind when we're considering sites in the round, so to speak. So it should have been something really that was considered the 2015 application, as opposed to a minor portion of that development through this application.
I think to be fair, we can duly note that though, councillor, you know, that this is something that perhaps ought to be considered in the future.
Well, they are quite rare these days.
Yes, I know,
They're often
and
found on the road.
I've read a little bit about
So
it, and yeah,
consequently,
the population is diminishing,
it
isn't
should,
it?
just as
Yeah.
much as the bats. I mean, I'm not quite sure how many bats they see over there, but my concern is that basically we're always a few years behind time in terms of what we should be thinking.
Yeah, I think just in terms of bats, obviously we do have mitigation to provide for that habitat. Obviously, when it comes to bats, it's not just provision of bat boxes that's important. It's the landscape and making sure there's foraging habitats available for them as well. And we do have tree line streets within the scheme, but I think the importance of this site certainly is the retention of the mature landscaping, which forms the periphery of the site as a whole. Obviously, the bats will use that area more than internally within the housing site for foraging.
Thank you. Councillor Collins.
Thank you, Chair. When we look at the education provision, it mentions provision for a contribution for provision of 3 places at either Newton Bluecoat School or St Joseph's Primary School. Now, we had a development in Newton, and the education contribution couldn't be taken up by the primary school in Newton, and at the time it went to Strike Lane in Freckleton. Now, that might be quite close as the crow flies, but to get there, it's quite a road journey. I think at the time it didn't form part of the rural East Fylde ward. Now it does. And at the time, because the contribution was going elsewhere, there's a bit of sort of like discontent about that. But now we see three possible places in New Bluecoat School. The question is, you know, how come money can be spent there now when it couldn't be when we had a previous development at Newton?
Yeah, I did raise this issue with the Education Authority. Unfortunately, they haven't got back to us. So I can't confirm why it's been considered previously that it can't be spent there, but now all of a sudden it can. I suppose the good thing is that there's 2 options available that are suggested by the Education Authority. So again, if it transpires that Newton Bluecoat can't be extended or altered, then the education contribution, there is still provisions for it to be spent elsewhere, and for that additional provision, education provision, still to be relative to the development that we're considering this morning.
If I could come in as well, and I don't know if Mark has got any comment on this, but one of the things that Lancashire County Council seem to be saying at the moment is that obviously their assessment of, well, I mean, these payments are there if, for example, in the local infrastructure, that is the local school network, there is deemed to be a shortage of places because of an expansion, because of a development, etc., because of the demand for places. And what they're saying is, this is their present assessment, I think, that at the moment they would assess that we need these additional places. But if you notice at the bottom of this, it sort of says, furthermore, the County Council will ensure that sufficient local that's their obligation, is to provide sufficient local primary places. Now, if they are not there, then the 106 click in, because that would provide that capacity in local schools. But it says, will ensure that sufficient local primary school places are provided to address the impact of the development at no cost to the owner. So in other words, if they feel that there is sufficient capacity within the existing system, then that money will not be paid to the developer. Because and the other thing that happens, I've learned over the years, that their assessments change because it's a moving feast, because the numbers go up, the numbers go down, and sometimes the places are there and that requirement is not there for additional capacity because they've already got sufficient. But it is, Mark, I don't know if you want to come in here, but it is the experience that I've had, you know, when we had the education liaison group, is that the figures keep moving and their assessment keeps changing because it's very difficult to be definite about projected need within the authority. That was just putting that in, hopefully that might be helpful. But before you come in, I'll bring in Mark as well, and he might be able to add something to it.
Yeah, I think that's the struggle that the Education Authority have in when they come to making these recommendations. They are obviously making a recommendation based on the number of bedrooms, for example, in that development, and that development as it comes forwards. It's not just this smaller element, it's the development as a whole that will be driving that additional demand. And whilst number of bedroom spaces is probably a fairly good sort of indicator of the number of children that will be there, there's nothing to say that a 4-bedroom house might not be occupied by a couple with no children or no children of school age. So let's say it's the best way in which they can forecast that, and it is based on forecast, i.e., what's happening elsewhere, what's the typical rate that's come forward on other developments, and that's what they use to deal with that. So as the chairman says, it's a very it goes through a state of flux really in terms of how things move on. And so what we have is the Education Authority make usually 3 recommendations. One outline, obviously not relevant in this case. One when you have the details with the number of bedrooms, and then one later on when they come to deliver the scheme in terms of where the number of children's spaces and the need move. I think in the past it's been fairly standard and easy to predict based on local birth rates, because that has been obviously if a child is born, there's sort of 5 years or 4 years, depending on as you move on, before the child needs primary education. So it's given time to plan. I think more recently there's been a much more fluid movement of people moving in and out with families already, which has made the things harder for the Education Authority. So it moves around, and then within that, obviously, which schools are available within that area. So I think the flexibility that the chairman's mentioned in terms of it's not just as though it's money contributed towards one school, that is one possibility. A snapshot in time, so that might have changed from when Councillor Collins said that it was looked at to today. But going forward, it's not just that one school, it's other schools that are named as a potential for receiving that funding. So it's not all the eggs in one basket. Thank you, Chairman.
Yeah, and finally, before I bring you back in, Councillor Collins, you'll have seen as well the sort of indication that there are a number of things that will be noted in terms of, Lancashire County Council apparently identifying potential schools, and that is whether they have. I've been there in this situation myself where sometimes you look at the site of a particular primary school and there isn't any room to sort of expand. And then there's a range of things looking, the governing body have to be on board that they want this, suitability of the site, etc., consultation with local schools. So there's a number of factors that LCC have to take into account before they actually identify those. So it's a fairly complex situation. And I think I'm right in saying that the present system will be that they hold funds, don't they now, Mark, rather than filed, because that was changed. So basically they hold the money, and then because they're making the decisions in terms of, where it goes and how it's spent. I'll let you come in now.
Yeah, I'm just a bit concerned that if 2 schools have been named and the money couldn't be spent at either, would the money then just go back to the developer, even though it might be required as a school further afield? Actually identifying schools when previously they've been shown they couldn't expand it. Yeah, here it is again. It's come forward. So would that money then be lost because they've identified 2 schools that perhaps couldn't be expanded?
I think my understanding is that the money could go back to the developer if they felt there was sufficient capacity within the network to provide the places that are required, notwithstanding the extra places that may be needed because of the development. But I'll bring Ian here.
Yes, Chairman. The principle behind any planning obligation, i.e. Section 106 agreement, is it must cater for a need which is thrown up by the development. So if there was no need for education places connected with this development, it wouldn't be possible for a planning obligation to require a generic education contribution. There has to be this nexus between the development and the need giving rise to the contribution.
Thank you. I hope that clarifies the situation.
Well, if it, Chair,
It might not be to,
well, no, I mean,
Yeah.
if it require 3 places and they can't be provided either at Newton Blue Court or St Joseph's, there's still a requirement for 3 places that is going to be provided somewhere. And yeah,
yeah, I'll
I
bring
don't,
that
want
back
to
in.
labour it too
No,
much,
no,
but yeah.
no, it's a fair point, and I think it's perhaps good for members to have this discussion as well, because we've got a number of new members, Councillor Collins, you know, on the committee, and they will not be as well versed or rehearsed as we are perhaps with some of these discussions. So I think it's pertinent, particularly in a situation where we've only got 2 items on the agenda. So I think we can indulge ourselves a little bit. Yes.
Yeah, I suppose that very point is the issue. So there might be the need for 3 spaces today, but there might not be in a few, you know, in a year or two's time. So because the situation is a state of flux, it might well be that, you know, a family with the children attending a local school move out of the area and that creates a vacancy. So, like I say, the issue is one of having to keep constantly reassessing the situation. As Mr. Curtis says, you can't require it just to, you know, for the sake of having that money. You have to have an evidence base to why you're asking for that money, and it's got to be needed. So you can't just sort of effectively put an additional tax on the development just because you feel it would generally add to local school places. So I think that's the key there. It moves up and down. So the only time when it would not be required, it would be if there wasn't any children, you know, if there was a vacancy. These contributions are based on vacancies. So if there is vacancies, the starting point will be we wouldn't ask for money because there's no need to address. So if we got to a point where there was no requirement in the local area for children, then there's no requirement in that local area. It wouldn't be a case that you could then use that money to go farther and farther afield to use the money on schools farther and farther away from the development, because the chances are children from that development will not go to those more distant primary schools.
All right. Okay, thank you. I think we've had a good discussion. Could I also note that Councillor Settle has arrived, and he will understand, obviously, you can't contribute to this particular item because the discussion has already started, but you will be free to contribute to item 2. And thank you for your attendance. So could we move, please, to item 2? Thank you, Rob. For
Page
your-
27 for those with paper copies.
There we are, thank you. Page 27, item 2, which takes us on to Oak Lodge, Wheaton Road, Westby, the Plumptons. PR43NE, postal code. And Andrew will be dealing with the presentation.
Thank you, Chairman. This relates to a property called Oak Lodge, which you see on the screen there is just on the eastern side of Great Plumpton, to the north of Preston New Road, out to the west of where we've just been talking about. The property is a detached bungalow. It's in a countryside location there. Excuse me. It was approved first in 1974 as an agricultural workers' property. The land holding associated with it effectively comes down here to the almost down to the road. So there was an agricultural workers' dwelling was approved in 1974. That property changed hands, and the current occupiers have lived there for a reasonable period. And it seems that they've been occupying the property in breach of the agricultural workers' tie, the condition that restricts its occupation to an agricultural worker. So they've pursued a lawful development certificate application, which is a way of
assessing whether they have been complying with the condition or not. And the evidence they've provided to us is that they weren't. So, and they've been in breach of that condition for over a 10-year period. Where a planning condition has been breached for over 10 years, it's no longer enforceable. So we've had to issue a certificate to confirm that the occupation of the dwelling without compliance with that certificate is now lawful. Sorry, without compliance with that condition is now lawful. So effectively, the condition has no weight, but it remains on the file. So this application has been submitted to remove that condition. So effectively, you've got a planning permission for a dwelling which has an agricultural workers tie, but there is a separate permission or separate certificate that confirms that that tie is no longer enforceable. So this application is looking to remove the condition from the 1974 planning permission. This kind of two-stage approach, we don't get many agricultural worker tie conditions, but where we do get them, we do get this two-stage approach. This one comes to committee because the occupier of the property is actually a member of staff here. So in line with the constitution requirements, that's why the decision needs to be made at committee. To try and sort of cover the probity elements of that, you'll see that John Copester's name is down as case officer. He's dealt with the application. He's not a member of staff at Filed. He's a consultant who we've engaged to ensure that there's that degree of separation between the assessment of the application and people employed at Filed. This is the property, just a little bit more detail. So you can see the house. There's an agricultural building to the rear that was in support of the agricultural activity when that was undertaken. That's property in Street View, and that's essentially just telling you everything I've just told you. So the application is recommended for approval.
Yes, Councillor Parrington.
Is the application of condition 3 pertinent to the individual or to the actual property? And my logic behind that is if the individual wants to sell it, but it's legally able to reinstate the condition, it might prohibit the sale. I just wondered if that's anything to do with it.
Yeah, planning permissions run with the land. So the current occupier isn't the original occupier. They weren't the original agricultural worker. So when they bought the property in 2000 or whenever it was, they would have been mindful of that agricultural workers' time, presumably complied with it at that time. And I think it's just a case that their employment has changed since then, and that's meant they're no longer complying with the tie. If they were to sell the property, then there would no longer be a requirement for future occupiers to comply with the tie if this permission is granted. So effectively, what was an agricultural dwelling what was an agricultural workers dwelling has now effectively stopped being an agricultural workers dwelling because the certificate confirms that that restriction is no longer enforceable. What this decision would do is that it would remove the condition altogether. So it's just a market dwelling in the same way that the majority of other properties in the borough are.
So just to follow up on that, I would just say that in a way we're considering whether it is beneficial to keep that condition in place for the well-being of the area, and that its removal obviously takes away the condition from the property and means there's no future mandate for anyone to have to be a agricultural worker. So in effect we're sort of thinking, is it beneficial to keep it there? In my opinion, but I'll leave that.
Yeah, I mean, effectively that is what we're doing, but and if this application came to us without this certificate of lawfulness, it would have a different recommendation, because the purpose of granting a property in the countryside as an agricultural worker's dwelling is that it is occupied by an agricultural worker, because otherwise, you know, we talk about policy GD4 quite a lot in this room, and erection of a dwelling in that location would conflict with policy GD4. It wouldn't be minor infill, it wouldn't be any of the other exceptions, so it wouldn't get planning permission. But one of the exceptions in GD4 is where a property is an agricultural, is to meet a rural worker's need, is the way it's framed now. So there would be the potential for the erection of a dwelling if that was, that sort of argument was justified. But because there is this certificate, because this isn't we're not looking at a sort of a blank sheet here, we're looking at a position where it has been legally proven that that condition now has no weight. That is a very strong material consideration in favour of removing this condition through the planning history, because it serves no value other than the only real thing it does is it probably complicates the matter for conveyancing solicitors when as and when the property does come for sale.
Thank you. Councillor Nixon.
Thank you, Chair. This is just related to the actual property and the surrounding area of the property, but the actual agricultural land at the back of it isn't included in any part of this. It's just that red square, if you will.
It's just that red square, yeah. The planning permission related to the
How
property.
does it affect the access to the agricultural building at the back of it? Because that looks like it's like the only access to that building.
The only vehicle access to that building is via the access that there. So the access point, you come through there and the driveway continues round the back of the garden and comes to the agricultural building that's located behind the property in that image. That is an agricultural building that remains in agricultural use. It would be for either the current occupiers or any future occupiers of this dwelling to either live with that access arrangement or to propose some alternative access arrangement. You'll see that Wheaton Road there is a classified road, so the formation of any access point would require planning permission, and the implications of that would need to be considered at that time.
So basically, who are living in the
The case law assessment of agricultural workers' conditions requires that they are occupied for purposes. The occupier of the property undertakes activity that is substantially related to agriculture. So what's happened here is the occupier undertook some agricultural contracting work and they reared sheep, I think it was, on the land, and I think they still do rear sheep. But the income from the sheep was a relatively modest part of their overall income as that changed over time, because I think they went from being an agricultural contractor and being involved in milking and rearing some animals themselves to into more of a sort of a domestic gardener type business, and they were able to convince this consultant working for us that their overall income over the required 10-year period had become so dominated, and the activity that they undertook during their working week had been so dominated by the non-agricultural work that they'd effectively been in breach of that condition. Therefore, the certificate was issued. That doesn't mean that they can't undertake any agricultural activity, and that's why this building will, you know, remain as an agricultural building and not available. You know, that's not removed from being an agricultural building, so that's not there as a, you know, as a vehicle repair shop or anything like that. It's still an agricultural building.
Want to be made redundant. At some point. So, thank you. It just sort of like puts that building at the back into just a redundant building. Because there isn't an agricultural element attached to it as such. It's just a building access to the back of somebody's property.
That's not an uncommon situation, though, is it? Where there are properties in rural areas that have buildings in land outside the curtilage that are used as stables, or as people who do hobby farming, or people who you know, like the circumstances I've explained here, where the overall income and work undertaken by an occupier includes elements of different types of activities, some of which may be agricultural, some of which may not. So that doesn't, this condition clearly only applies to the dwelling. So the removal of it that we're discussing here clearly only relates to the dwelling and doesn't have any implications directly on the agricultural land or the agricultural buildings, or the building associated with it. That would be a matter for either the current occupier or future occupiers to either comply with or submit a further planning application in the future, should they wish to find an alternative use for that
fear
building.
that this is the first step on the ladder to getting rid of the agricultural use of that building property, and then it just becomes another house in the countryside that isn't attached to a agricultural use as such. Whereas it previously was,
excuse me to cut across you there, councillor, but to be clear, that is what this application is for. This application does remove that condition, and therefore, if approved, would allow this to be a market dwelling in the countryside that I could buy if I wanted, or could afford.
Okay.
Councillor Pittman and then Councillor Farrington.
Thank you, Chair. Now that this agricultural tie obviously has been lost, does it mean that the owner of the agricultural area cannot ask for another, or put in another application in future for another agricultural home for an agricultural worker? That doesn't preclude another application if he has an agricultural worker that he wants to house.
Yes, if there is the opportunity for an application to be made on any piece of land anywhere at any time, with this being in the countryside, there are the restrictions on development in the countryside that apply. One of the exceptions to that is for a rural worker. So if we were to get an application, if somebody wanted to put a dwelling up in this location, they would make an application. They would potentially submit evidence to demonstrate that there is a need for an agricultural worker to support the agricultural activity that's taking place, and we would have to assess that on its merits at the time. I think one of the things that we will be looking at there is whether there actually is an essential need for an agricultural worker based on the activity undertaken at the site. And given the depth of evidence that was presented to the certificate application, it's clear that the current activity undertaken on this land holding that's of an agricultural nature, it is quite limited, and certainly way below what would be necessary to justify that there is an essential need for an additional dwelling. That's not to say this land won't be bought and become part of another farm, and that may allow the next generation of whichever farm to want to have a further dwelling to support their use of it. But I think on the scale of the land here, the level of the activity undertaken, I think it's very unlikely that an application for a future rural worker dwelling would be supported. We'd also have to look at other factors like the location of it, the design, the access, whether there are other rural workers' dwellings available in the area that could provide the need for that dwelling. And there's a range of policy hoops that any applicant would need to jump through if they wanted to pursue that. So I fully appreciate the concern, but I don't think it's realistic that there would be a justifiable case for a further development on this particular site.
Yeah, I do appreciate times have changed, and in 1974, maybe there was a real need. What does surprise me is the size of this agricultural workers' dwelling, because once upon a time, agricultural workers didn't get such a palatial area, and this was obviously a very special agricultural worker because it's large, and it was obviously very valuable in terms of its sale. But yeah, thank you very much for that.
The property has been subject to extensions since it was first built. Looking through the planning history, you can see that there are kind of three elements to it. So going back to the image, I think that was probably the original dwelling. I think that's been added as an extension, and I suspect there may have been a garage at the other side that's become habitable accommodation. So it definitely is a sizable property now. But I think you know, going back to 74, it was more modest than what was now, what's there now, in line with, as you rightly say, the scale of agricultural workers' dwellings. That on the few instances that they are approved now, we are always looking at them as though they are relatively small scale properties, and that's one of the tests in the current local plan policies, that they would need to be of a size that's commensurate with an agricultural worker's need or rural worker's needs.
Councillor Harrington.
Thank you. I think one of the concerns I have is that if the property is bought by what you'd call a regular family who aren't in agriculture, a likely scenario could be that the buildings at the back are rendered redundant in a way, unless they, for example, have family that have ponies and they convert them to stables. There'd be no necessity for them to maintain them. And, you know, I just wonder from the perspective of preventing them falling into disrepair, which would obviously not be great for the surrounding area. I just wonder legally what steps or measures might be within the power of the borough to ensure that can't happen.
The buildings in question are perhaps about 10 years old, so they are modern style Warings buildings. So in terms of immediate risk of falling into disrepair, I think that's quite limited. My experience of handling calls from people who are looking to buy properties in rural areas in the office is that quite often there is quite a market, quite a demand for properties like this, where they're in a rural setting. People are looking for properties with outbuildings for hobby farming, or you know, they've got an interest in equestrian activities. So I think it's quite likely that this property, if it was on the market, would appeal to somebody who wanted to use those buildings alongside the domestic use of the property. So I think it's unlikely that the fears you express would be realised, both from a sort of practical use of the property purpose and also from the, you know, the age and condition of those outbuildings. But there are, if they were to fall into disrepair, there are powers available to the council to tidy up untidy land and buildings. But I think, like I said, I think because of the scale and quality of the construction of those, I think that's highly unlikely in the foreseeable future.
Chairman, if it helps, there are a range of powers available. There's planning powers to deal with buildings which are injurious to the amenity of the neighbourhood. So a notice can be served. If that was the case, there are powers under the Building Act for dangerous and dilapidated buildings, and there are powers under the Environmental Protection Act in relation to public nuisance, which can arise from the condition of a building. Just on the wider point, Chairman, if it helps, the decision in this case is whether the condition should be removed, which amounts to the difference between there being a condition which is legally unenforceable and there not being a condition. From the point of view of the local planning authority, there's no difference at all. A condition which is legally unenforceable might as well not be there because it can't be enforced. From the point of view of the applicant, the advantage in the condition removed is there will be a measure of faffing about during any conveyancing process removed. What would typically happen with relation to this condition would be that the buyer's solicitor would, if they're doing their job properly, as you would hope they would spot this condition, would make inquiries about whether it's been complied with or what the status of it is. The seller's solicitor would then say it's unenforceable and I've got a certificate of lawful development which shows this. The buyer's solicitor would then have a look at that. If they're not familiar with certificates of lawful development, would seek some further advice on that. And then after maybe a delay of a few weeks due to that, the conveyancing process would go through. So from the owner's point of view, it's removing that additional level of inconvenience from the conveyancing process. From the local planning authority's point of view, it makes no difference because the condition has been legally established by the issue of the certificate of lawful use to be unenforceable. Thank you, Chairman.
Thank you. And I think a key point is this certificate of lawfulness, which in the report it says has the effect of confirming that the council can no longer enforce the agricultural workers condition. But within the assessment of that, you can see there's an assessment of agricultural activity, which wouldn't have justified that. So it's removing a condition that couldn't have been enforced. So I'm going to go to Councillor Evans.
Thank you, Chair. Thank you to the learned Mr. Curtis as well for making that very clear. To me, it's just a tidying up exercise, realistically, paperwork-wise. The agricultural building at the back, you know, like you say, these can be used for multiple purposes, storage, vehicles, all kinds of different things that people moving into the countryside would repurpose. But for any strategic change of use, they'd have to go through an application process. So, you know, if we accept this recommendation, it has no impact on any future change of use development of the site as a whole or the individual buildings on it. So I'm minded to recommend for acceptance.
You're moving approval, Councillor Collins, and you'd like to second it. Okay. Could I just thank members though for the process that we've just gone through? Some very insightful questions and raising a number of issues. So it's really important. And so those who have asked questions, thank you for that, because I think it's clarified a few things in my own mind as well. And so that's where that debate is helpful. Yeah. We've had a mover and a seconder for this. Can we see all those in approval, please? In favour?
That's unanimous, Chair.
It's unanimous. Okay. Useful to have this opportunity.
Yeah, as the chairman says, we don't lose that many appeals because we put effort into trying to resolve matters wherever we can. As as you see in the meetings here, but this is one that we did lose. It relates to a dwelling on Cheltenham Crescent, this is Salt Coats here, Green Drive down there, and Salt Coats Road going up to the tip and out towards Moss Side that way. So it's a typical residential arrangement, cul-de-sac, semi-detached houses built in the 60s, 70s maybe. And what's happened is that the garage to this property has been converted into an Airbnb unit. So that was being rented out. They did it without planning permission. It was being rented out. We got complaints about that to the enforcement team, about the sort of the nuisance that was generating to neighbours, and the applicant decided to submit a planning application, which we refused on the basis that it was not an appropriate location for a self-contained unit, given that it's entirely in the back garden. The only access is along a driveway that's effectively shared with the adjoining property. They've got a kitchen window on this side here. You've obviously the adjacent property. You've got the adjoining property's garden that there was that close relationship there. So we felt that there was an amenity issues on neighbours. We also felt that the parking arrangements weren't ideal, because you've got two people. You've got the occupiers of the property, their parking and access requirements. You've also got the visitors who are coming, and where do they park? They're coming and going because they come into the site, stopping a night, going out, coming and going quite a bit. You're in the turning head to this cul-de-sac, and we felt that there were concerns there justifiable over the limited level of parking and the comings and goings that will be created by it. This is the situation in a photograph. So you can see they've called it Sea Salt Lodge at the back. You've got the neighbouring properties window there. It's just a garage with some cladding and a door added to it. You know, it really is quite small accommodation inside. It's a single room, sort of a bathroom in there, bed, sort of kitchen. Like I say, we refused planning permission under delegated powers as officers on that amenity basis. And that's really just explaining that. The inspector disagreed. He granted planning permission for it. Basically, he felt that the disturbance caused would be limited because it's only a single bedroom flat. He also felt that because the guests, the visitors to it, would be visiting and then going off to see attractions wherever, you know, during the day, they wouldn't be around most of the time. We'd made the point that visitors would be more likely to be socialising. So in a summer evening, you might be sat outside the front of that garage with your glass of wine more often than, you know, the normal residents might be because you're on holiday. The inspector also made the point that none of the neighbours had objected to the application, although they hadn't. Whilst they hadn't objected to the application, we had complaints at enforcement stage. So, you know, and it's an indicator of impacts rather than, I would say, being a determinating factor. There were no privacy issues. They felt that because you could put this attractive bamboo screen up to this side, it meant that you know, you wouldn't see across that fence. Well, that's probably true, but then you've got the design and the relationship issues that creating the fence, erecting the fence creates. And essentially the inspector got it wrong, didn't he? But these are the issues that were raised. The inspector accepted that he imposed a condition to require that the front garden to the property, which I don't know that I have an image of. Yeah, the front garden of the property be removed and a bank of 3 parking spaces be provided, which perhaps going back to Councillor Pittman's point this morning about hard surfing in the front areas, obviously the inspector felt that was an acceptable arrangement in this case. We'd also made made a point about a fear of crime due to the next door neighbour experiencing people coming up and down the driveway opposite them that they wouldn't be familiar with, potentially coming back late at night, you know, from these local attractions that they're visiting, and raised a point about that, but the inspector just dismissed that. So normally appeal decisions are a good indicator of how we are dealing with applications, whether we're right, whether we're wrong, and things that we should be looking at. In this case, I've been asked to explain it to you, and the only explanation I can give is that I think the inspectors made a poor decision here. But that's where we are.
Yeah, I mean, it's just interesting, actually. I'll bring in Councillor Settle as well, but listening to that and the judgment of the inspector, it sort of throws up, doesn't it, this business that we're all in when we are looking at applications, and that is basically weighting of various factors, because there's a whole host of factors there, and you could go either way, couldn't you? And the planning inspector has gone one way, and we, you know, the officers have decided this was not acceptable. I tend to be on the side of the officers on this one, to be fair. I just imagine that if this was presented to us, there would be a lot of concerns about the juxtaposition of the garage as a place of sort of for visitors and maybe a little bit of entertainment right next to a private driveway and a private residence, etc. But my question really is, in terms of weighting, it seems to me that he must have given a fair consideration to the lack of objections from neighbours, and I'm just wondering whether that is sort of encouragement to people to sort of go, if you've got any concerns, object, because it might have a bearing on it. I'm just throwing that in. What do you think, Andrew?
Yeah, the planning legislation requires that we notify neighbours, and it requires that we consider neighbouring objections. So they are a material consideration in a decision on a planning application, and you know, we've all heard members of the public speak to committee, and no doubt you've taken account of what's been said. The decision-making situation, though, is based on policy. So we are able and you know, regularly do have to set aside comments made by neighbours on planning applications. But I think it's a stretch to say that just because there aren't any objections to a particular application, it means that any concerns over the impact on their amenity are unfounded. It may be that the occupiers of this property, maybe that property is vacant. You know, it may be there may be a sale going through and there's nobody living there, and that's why they didn't comment on the planning application. Who knows? But we still need to consider how the activity associated with having separate occupiers of that property could impact on their amenity, irrespective of the lack of comments.
I suppose I'm going to bring in Councillor Settle and then Councillor Collins and then Councillor Evans. To what extent, when you get an appeal decision like that goes the sort of wrong way, do you have to, however, although we don't like it, but you look at what the planning, you know what I'm coming to here, is when you look at what the planning inspector is actually saying, and sometimes the evidence we have when we're looking at existing planning applications are quotes from planning inspectors sort of appeals in the past, because are they material considerations as well? I think they are, aren't they? But to what extent do we then factor in that judgment in terms of future applications? And would you pull this one up to sort of say, we've got real concerns, we're recommending refusal. However, we have to point out that in this judgment by the planning inspector, he found in favour, you know, therefore, you know, although you judged the application in front of you, which is a really important principle, it is bound, is it something that will be brought into that sort of judgment at the end and the recommendation that you guys make?
Yeah, when we're as officers dealing with applications, we do so in a collective way. So the case officer will visit the site, they will look at the scheme and will come to their views, but they won't make the decision. Rob, Matthew or myself will make the decision in almost all cases. Between the officer getting the file and the senior officer making the decision, there's quite often a discussion between them about the various merits. Sometimes there's a team discussion if there's a particular point that we're all unsure of. So we try and reach a consensus. When we get an appeal decision, they're circulated around the team, and I try and pick out the relevant points of them to see if there is something in there that we can use as a way of, or we should be using as a way of reaching those consensuses in future assessments. So particularly where we've had decisions relating to the scale of extensions and replacement dwellings in rural areas, policy H7, we've used various appeal decisions in the weighting there. I suppose the underlying factor is whether the inspector's making valid points and has made a reasonable assessment of the case. Here, I don't think he has. So I'm not going to be suggesting we use this as an indication that every time we get an application for somebody to convert the domestic garage into a separate Airbnb, we're going to approve it because of this situation here. I think we need to be a bit more need to have a more detailed look at it than that. But it obviously the inspector's there and he's made that view.
Thank you. That's really helpful. Councillor Settle.
Thank you, Chairman. It's obviously an appalling decision, this one, on this particular case, but nothing we can do about it now. But more worrying thing is it could set a precedent. Thousands of houses like that are in the file with a garage at the back, and people might get the idea that they can do the similar thing. I'm just wondering whether we could have a new policy that actually states that, and this isn't a case where they create a granny flat, that's completely different. An Airbnb for rent situation is completely different. Whether we could have a new planning condition that says that Airbnbs in a typical situation like that, behind closely packed houses, is just not acceptable. Any other comments?
You've raised Mark, do you want to respond? Sorry.
Yeah, so I suppose the first thing in terms of a new policy, we'd have to obviously go through a process of amending the local plan to do that. So it wouldn't be a fairly straightforward, because as we've heard from recent training, things like supplementary planning documents can't introduce new policy, they can only provide guidance on existing policy. But in terms of, so we could have a less formal policy, but then the weight that could be attached to that would be lesser. I think in terms of this, and I know that there's a wider issue with Airbnbs across the country, not just in Fyle, but about actual properties being used for that type of use and causing disturbance to neighbours, etc. Because by their nature, people are on holiday, they're moving through. Quite often properties are rented to celebrate someone's birthday. So whilst your neighbour might only have a couple of birthdays a year, if it's the Queen, then you could have a series of week after week after week. And I know that's an issue in the Lake District where people bring fireworks and set fireworks off every weekend because every weekend's a birthday. So you get more disturbance than you would from a regular property. So Airbnbs in general is an issue. At the moment, that might, like I say, quite often doesn't need permission. But in terms of this one, obviously, where they've done physical work to convert a building, that's a different matter. I think the issue is going back to this is there is sufficient in this because what it is it's about the material considerations that said whether this was acceptable. So if you had a policy that said we'd only allow these if the situation was acceptable, whether you got the policy or just addressing material considerations, somebody could come to the same assessment against the policy or against material considerations and get to the same position. Excuse me. I don't know how much, when you're looking at a situation like this, it would add to the decision-making process. And I think because a lot of this relates to the circumstances, again, what Andrew says is that it doesn't create such a precedent for us. Clearly, people will point to it when they apply, when they apply for similar things. Oh, well, this one was allowed on appeal. But what you'd have to do is sort of say, well, that was to do with the circumstances there. And then with that issue about the neighbours not objecting, I mean, that's always been an issue that's not been necessarily. So we don't refuse things just because people object. And likewise, we don't approve things because there are no objections. It's always been a way, all the training courses that, you know, that we've brought people in to say that's the issue. Because what you try to be in planning is consistent. So if you've got two identical schemes, one where neighbours object and one where they don't, clearly you should really be looking at them in the same manner, not coming a different decision because of objections in different situations. So in terms of this one, like I say, going forward, it clearly does create an issue which some people might try to jump on the sort of coattails of to demonstrate their scheme is acceptable. But I think also we could equally justify why we might see another scheme somewhere else, because this is very much down to the individual circumstances of that one particular scheme. Jim?
Yeah, I'll bring in Councillor Settle, because it's interesting, because, you know, when you sort of mention about the neighbourhood objections, that's exactly what the planning inspector is doing, is using the fact that a lack of neighbourhood objections is being used as an argument for saying, you know, what's the problem? So it's interesting. Councillor Settle, you want to come back?
I think maybe then he's put too much weight on the fact there's lack of neighbourhood objections. We as authority objected on far wider grounds than that. Mark's just reminded me though, we had a debate recently about Airbnbs in general. I can't remember what it was. It might have been in our finance meeting, but pre-May that is. But we've had a very big concern about Airbnbs generally across the file, not just this situation, but people Airbnb-ing out their normal houses. Just wondering whether there's some sort of debate we could start in Fylde about Airbnbs in general, because we all know that Airbnb started by people just going on holiday for a few weeks and renting their house out. And the government was all right with that. Now we're seeing properties that are rented out 52 weeks a year, which is not the idea at all. So no one's really confronted that issue. This is just a subset of that. So just wondering whether you could have a discussion about whether we should have a discussion about Airbnbs overall.
Mark?
Yeah, I believe that's on the scrutiny committee's agenda. So yeah, I'm not sure it's internal, external, but yeah, it's one of them anyway. Yeah.
Okay. Councillor Collins, thank you, Councillor.
Thank you, Chair. I take it this is a self-contained flat. Yeah, but with a business use as an Airbnb. We just had an agricultural tire being removed a bit further down the line. If somebody wanted to remove that business use and have it as a granny flat, would that be difficult to resist? Would it be sort of an automatic?
Yeah, I mean, the requirement for planning permission relates to it being used independently of the dwelling. So if they were to revert it to a granny annex, a residential annex associated with the occupation of the main house, that will be supported, because that deals with some of the concerns as well. So the fear of crime issue about unknown people, the people, you know, the Queen or the King only have 2 birthdays a year. You know your granny only has 1 a year, so you get away from that. You get away from that amenity issue straight away. So all those things fall back into line. I think the question is if we were then to get an application for it to be an independent dwelling, I think that would be something that we would look to resist because of the scale of it. It's not meeting the minimum size standards for a habitable dwelling, which apply to residential dwellings but don't apply to holiday accommodation. It's not, potentially it's providing realistic parking, but again, you've got close relationships with neighbours, you've got inadequate amenity space for the existing dwelling and for the for what would be the new dwelling. You've got that poor relationship being in somebody else's back garden. So first off, it would require planning permission, and second off, I'm fairly sure we'd be refusing planning permission if we were to get an application for it.
Okay, thank you for that question. It's Councillor Evans.
Yeah, thank you, Chair. I think it just highlights the fact, my thoughts of Airbnb is exactly like you said, a house in the lakes or something, a property that you'd rent. But in reality, you can rent a room out on Airbnb if you wish to have your spare bedroom in the house. An awful lot of people have got garden rooms, from a conservatory to an office to a granny flat to an occasional relative stay. And then it moves on to, well, what do we do with this space in the downtime? Well, we could rent it out. So, it is a growth area. I think it should come to scrutiny. I'm sorry, Vince, but I would have thought it would sit in external scrutiny with it being. You'd have to explain that to me afterwards, because but anyway, that's be interesting to see what the outcome is on that. But I would have thought the only angle we can look at is in terms of building regs and making sure that if a shed, garage, outbuilding, garden room is being let to a third party, that obviously there's got to be some fire prevention, smoke alarms, correct glazing, certification for any gas heating, electrical testing, things like that. So those are the areas where presumably we've got a bit of leverage with the building regs that we could enforce some of those things there, because I think a lot of these things start off as not as a business idea as such, just there's a bit of space here, can we make a little bit of money out of it without taking in the full rake of responsibilities that somebody needs to, even down to insurance.
Thank you. We'll go to Councillor Ledger and then Councillor Farrington. Just to add to that, of course, all the real concerns about all these developments that might start very humbly in a certain way and then become something else is always, from my point of view, what is the impact on the immediate residential amenity? And you look at something like this, for example, quite narrow side drives, people moving up and down that are just visitors, not known locally, etc. And then you have a sort of project like this, which basically plants it right in the back garden, right next door to somebody else's back garden, and pretty close to other houses as well. And so it does raise a lot of issues in terms of the impact, in terms of amenity. Residential amenity.
Well, it does, Chair, but it also I've seen on news and various different programmes that if you look at London and places, cities where there is a greater need for accommodation, that people living in converted garages in not good conditions, and they're living in them all the time. I'm not suggesting that this application is designed for that process, but it does highlight the need for some view of what constitutes an occasional dwelling and what then becomes a permanent dwelling for somebody.
Councillor Ledger.
Thank you. My questions were similar to other people, so I think they've already been answered. I'd be curious to learn more about how our policy on Airbnbs, or what even the general national rules are on holiday lettings and stuff, because I'm not sure I fully understand. I imagine the people who built that without planning permission, so there's nothing we could do when they built it, was I guess Leaden Festival, and I remember this year it was absolute kind of chaos, driving people, friends and family around. So yeah, I'm concerned like everyone else about precedent of other people. But it's not even a garage; it's a shed. Just being converted, but yeah, I agree with everyone else. Is there a way we can get ahead of this? Not to be necessarily against holiday lets, because that's good for the area, but we don't want sheds in the garden to be like the synonymous with Fylde. The Leaden Festival.
I think that's perhaps the point I was hoping to make at the start, is that whilst we've had this appeal decision and like's been said, others will no doubt point to this and submit applications on its coattails. We need to look at whether the inspectors reached the right view, and I'm not taking this as being a sort of opening the door to approve a load of other similar schemes. I think if we had let's say half a dozen appeal decisions that were along this line, would perhaps they sit up and think, actually, we should be supporting this for whatever reason. But, you know, we're a long way from that now. And we'll just have to see how that goes. I think Mark's waving at me again.
Yeah, sorry, I suppose the other thing is in terms of the situation at the moment, use classes order divides different uses into different categories. One of those is as use as a dwelling house, and nothing within that use class separates out how you use that dwelling. So whether it's owner occupied, whether it's tenanted, whether it's used for holiday use, whether it's rented out for holiday use. So there's all those types of different ways in which a dwelling can be used. It can also be used with an element of care provided on site. So class C3 is quite a broad class. And I think that's the issue. So in places like London, there is a rule that says that you can't let out a property for more than, I think it's 90 days, 90 nights. So there's all the restrictions on that don't apply for the rest of the country. I think Edinburgh have had a similar issue, and so they've introduced local bylaws, but it's not. I don't think those are planning restrictions as such. But certainly nationally, this whole issue, you know, when you go to some of the smaller villages in, and even some of the larger villages in Cornwall, for example, the whole place is just, it's just all holiday accommodation, which puts a hole through the local community and makes property more expensive. So when you're in areas like that, perhaps it's not to that scale here, but if you've got an issue about the number of houses you're trying to provide for, for local residents, if you get to a certain scale, then you start to take, those properties, so there aren't places for local community to live. Like I say, that's not a level that we've got to in Fylde, but it is, it's an attractive location to come to. It does have holiday attractions. It has got facility, events, as you mentioned, that make it attractive. So you could see a scenario where it grows and grows and grows. So yeah, it's going to be an interesting one going forward as to whether. And sorry, the government did launch the consultation some while ago now on two aspects of control over Airbnb type of accommodation. One was to do with licensing it, and the other one was to do with the planning regime. So it is clearly on the radar nationally as something that is a potential issue. So the suggestion was to separate off rental properties, to make it permitted development to change to them, and then if an area for that permitted development changes to holiday accommodation was a problem for them, they could then impose an Article 4 direction to take that automatic right away, and that's how it would operate. But as of yet, we've not seen any response to that consultation.
Yeah,
Thank you,
that's,
Mark. I'm going to bring the Vice Chair in quickly, and then Councillor Barrington, and I think then we'll end the debate, because I think we've had a good amount of time to discuss in this. I'm hoping that you all feel that this has been useful. So, Vice Chair.
Thank you, Chairman. Yeah, I think nationally at the moment, the whole situation with Airbnb, it's a bit like the Wild West, isn't it? And we are waiting for the relevant minister to put his 10-gallon hat on and ride into town and save us all. And I think, hopefully, this legislation, when it finally does come, will inform us, it'll inform the inspectors, and it'll inform the owners of Airbnbs, and hopefully that'll address some of the issues that Councillor Settle's scrutiny committee is going to raise.
Well, the internal one, he's
Oh,
community
I beg-
focused.
I beg your pardon.
Okay, thank you for that.
Thank you, Chair. I think unfortunately until the sheriff rides into town, we're going to have bigger problems, and they're not necessarily about outbuildings, because when you look at online about property investments, because of the latest legislation, it being more onerous for landlords with permanent tenants or long-term tenants to get the yields they used to. A lot of investment opportunities are now turning to the notion of getting properties and making them Airbnbs. So this problem is only going to get worse in the short term. And I just think we need to be mindful of that in the area. There's nothing potentially we can do about it, but I can see that it's, you know, the major problem is going to be just properties coming onto the market, being snapped up, and instead of being rented out, being turned into Airbnbs, unfortunately.
Yeah, and I think we share those concerns, and I think the line of questioning and the level of debate, and I'm very grateful that we've been able to discuss this particular appeal decision, but for the wider implications, they're huge, and I think it is something that we will have to keep our eye on. And as you say, we're probably quite limited in terms of what we directly can do. But, you know, in any forum, I think we need to express the views that we have, that we've got concerns about this sort of rather ad hoc sort of allowance of these sort of particular properties and enterprises. Right, I'm going to... They might well have decided to take that view as well, to be able to say that, to protect their own local reputation, you know, because if they seem to be sort of, you know, facilitating this sort of development in a way indirectly, it wouldn't be commercially very good, would it? So it may be that they've made a business decision there as well, regardless of the grounds on which they can actually say that.
And I also wonder, in this area, we have a lot of leasehold properties, and maybe conditions of the standard leasing to do with subletting would prevent it. I know leasehold is something that nationally is being looked at in another way, but this is possibly a positive aspect of that for us in Fylde.